Good morning, Your Honor. Lisa Rasmussen on behalf of the Robertsons.
Good morning.
Morning, Honor. Sean Payne on behalf of the counter defendants, Robertsons.
Good morning.
Good morning, Matthew Friedman, 11571 on behalf of Fraser Inouye.
All right, good morning. And you have your client in the courtroom?
He is.
Okay, yeah, come on up. All right. Okay, so this is on today for defendant Fraser Inouye's renewed motion for a more definite statement, or in the alternative, motion to dismiss. So let me kind of tell you what my thoughts are on this. I'm inclined to grant the motion in part and deny the motion in part. I'm inclined to deny the motion with regard to the breach of contract claims to include the breach of the implied covenant claims. I have some questions about these claims. They're more rhetorical questions at this stage, including what the damages might be. But I think as pled is legally viable to withstand a 12B5 motion. I'm inclined to grant the motion with regard to the negligence claim, although I'm prepared to be persuaded otherwise. But I need some further information and explanation as to what Mr. Inouye's duty was, meaning how it arose and what conduct breached that duty. Right now, as I'm reading the complaint, it seems that plaintiffs are pleading that duty arose as a result of the same contract that serves as the basis for the breach of contract claim. And by the way, that becomes an economic loss doctrine issue. But presuming you pled negligence in the alternative, you know, if the court finds that no contract was formed, I'm not sure as a legal matter still how Mr. Inouye had a duty to protect any of the plaintiffs from the conduct of third persons, meaning Kody Gorden or Michael Stiles. And as a general matter, it's not entirely clear to me, at least with regard to the negligence claims, what specifically did Mr. Inouye do to plaintiffs? So that's where I'm at. Let's start. It's defendant's motion to dismiss.
So Judge, and I understand Your Honor's sort of wet read, so to speak.
It's late.
So our take on, and we understand, notice pleading versus fact pleading, and the standard is liberal here, but we do still think on the contract claims, they have not identified what this contract was, or even the terms of it, even in the most general sense, right? Offer acceptance, mutual consideration, like we don't see that. And so that's where we're asking for a more definite statement is, what are you saying? And it kind of ties to what Your Honor just indicated, which is, where is the duty arising? If you're saying the duty arises in tort theory under a liability, a negligence claim, okay, articulate what his duty was. And then if it's a contract, then explain what's the contract that provided that he was supposed to act in some way.
They said that. Look, the contract is not, as I read the complaint, there's not some form agreement that, this isn't a vendor contract or a sales contract where, Mr. Inouye directly contracted with the plaintiff, right? Like, I'm going to provide you accounting services. Please sign my retainer agreement.
Right.
This isn't one of those things. It's one where, by virtue of their relationship with Rawlings Tigers,
The baseball club, the club itself.
It's by virtue of their relationship, each party's relationship, that they have somehow, the Robertsons, by signing their kid up for the club, have agreed to adhere to certain standards. Mr. Inouye, by being a volunteer and by being the team accountant, I think, has agreed to adhere to certain standards of the club. And that's what they're alleging formed the contract. Whether that carries the day, I don't know, but it's Rule 8. That's the thing. It's Rule 8. I know enough. Like, I could respond to the complaint. Whether or not it in fact formed a contract, I don't know.
Isn't the theory, though, then more of vicarious liability that they're articulating? I mean, effectively, if it's the club's code of conduct and you're claiming that it was breached by a volunteer or breached by an independent contracting accountant, then aren't you really saying that the club itself breached its duties by having a volunteer? Right? That's
I don't know.
what I struggle with. Understood,
Yeah.
Judge. But I understand where you're going, and we will answer it and do some targeted discovery on it. That's fine, and I appreciate the court's inclinations and rulings. As far as negligence, and we briefed this for Your Honor, I agree with you. I don't think at a basic level they've articulated the duty. And to be fair, Judge, this was before Your Honor previously. The negligence claims were dismissed previously for the same reasons. And so we think that this amended complaint suffers the same fundamental defects. And we think that claim should be dismissed.
Okay, Ms. Rasmussen, we're waiting on contract. I'm likely not dismissing that one, but negligence, I'm having a really hard time grasping what the duty was, how it arose, how it was breached, and what Mr. Inouye specifically did to plaintiffs.
Well, Your Honor, I think the contract creates duties. And
But that's the problem, is
Well-
that you have the economic loss doctrine then.
right, but I think I'm able to plead it in the alternative, and I disagree with counsel that this is the same negligence language that was brought before. It's not. In fact, I substantially cleaned up this complaint and got rid of things that I didn't, I'm not the original architect
I know.
of this. We all know that. I wouldn't have pled things this way for reasons that the court may know. I'm not sure that opposing counsel understands.
Well, what I know from I know the original claims are pretty much gone. We were moving forward with defamation, and I think they're gone now, right?
Defamation consortium.
I cleaned it up
Yeah.
in the way that I believed was appropriate based on the information that's available at
Right, but
this.
defamation is gone now, right?
Correct.
Okay.
Okay, so it is not a vicarious liability theory. There are specific and they're attached to the complaint, by the way.
You don't have to talk about
like-
the breach of contract one. I get the.
No,
and
no.
I don't think it's vicarious liability, but I need you to answer these questions on the negligence. What is the duty? How did it arise? And what did Mr. Inouye specifically do to breach that duty? Because that's the information I need to decide this
The
motion.
duties arise out of the contract.
Okay, then how do you get around the economic loss doctrine?
Well, Your Honor, I think that I'm entitled to plead, I guess I'm just repeating myself and maybe.
You are entitled to plead in the alternative, but
Right.
if you don't have a contract, the duties can't arise.
Well, okay, but the duties are that everyone is supposed to act in a certain way. Okay, he clearly breaches, and this is in my facts, he clearly breaches that duty when he becomes aware that Brittany Robertson was sexually assaulted by one of the team managers, and he continues to act in a manner that is contrary to the conduct. Certainly I'm not alleging, and I don't think anyone else that preceded me did, that he was part of the sexual assault, right? But once he becomes aware of it, that's a breach of lots of things. It's, it's
So
many
does he
things wrong with
have
it.
apart from the contract, does he have a common law duty? Is there a duty at common law that arose that required Mr. Inouye to protect Mrs. Robertson? And
Well,
protect her from what, since this is post-sexual assault?
but it's his conduct after he learns of it that's so egregious. He continues to basically engage in hazing behavior and harassment. And instead of saying, yeah, this is not how we're supposed to treat players and their parents, he in fact is involved in a scenario where they've sent a cease and desist letter, and he's participates in this thing where they work around and they go through their children's Facebook so that Mike Stiles can haze the minor child of the Robertsons. I mean, he does all kinds of things after he learns about it that I believe are negligent behavior. Now, I think the question you're asking is, are these things tied to the contract, the team standards? Right? The team
No,
standards.
that's not what I'm asking. I'm asking is, apart from the contract, is there a common law duty, and what did Mr. Inouye specifically do? Or what did he do? And then what are you saying he didn't do? Because those are two different standards. There's a duty to protect arises only in very specific circumstances under the common law. And then, if he did something, if he harassed, if he did something specific and you've pled that in the complaint and I've missed it, then that's also a different story. If he specifically did something as opposed to he didn't stop someone from doing something.
Well, I believe he participated in the after the fact harassment by allowing his son's FaceTime to be utilized to get to the Robertson's child. That's the one thing. And he's clearly there when that happens. He knows that it's going on.
And then what claim, let's say what is that claim? Is that negligent infliction of emotional distress?
Yes.
And then how does that, for negligent infliction of emotional distress, you have to have like really outrageous behavior under the case law. So is there any, it seems like just allowing your kid's FaceTime account to be used does not rise to the level of what courts have previously said is really outrageous behavior.
Well, Your Honor, I'm answering your questions as best I can. I believe that that negligence is appropriately pled in the alternative to the breach of contract theories. I understand what you're saying, that if the duties arise out of contract, that's a different issue, but there's also negligent infliction of emotional distress here, and that's the way I pled the negligence claim.
And the action that you're saying Mr. Inouye undertook for the negligent infliction claim is he allowed his son's FaceTime to
That's
be
one of
used?
the things.
Okay, what's the other thing?
The other thing is that, and this is in the third amended complaint, they did a workaround to allow Kody Gorden to remain involved with the league and the team. And he participated in that, and knew that it was happening and knew that it was against the code. They initially said, well, we're going to remove him. Obviously, this is bad, right? Everyone knows that this conduct is wrong.
I don't think everybody said that. I think a lot of people were saying, I don't think this ever happened, but.
Well, that is maybe what they were saying. I missed that phase of the litigation, but they settled. Okay, so, but the league agreed, or the organization agreed to remove him, and then they created this workaround where we'll just move him over here and he'll be a consultant, and Inouye was part of that. These are things that are all done after he has knowledge of the egregious conduct or the allegations of it. And then there is also the fact, and I did remove the defamation claim, but there's still the fact, this fact remains consistent, that Brittany Robertson is at a baseball game where a parent who's just joined the league comes up and sits next to her and says, and basically tells her story. Like, he's heard the whole story that there's this hot doctor wife.
Yeah.
And so, he's not doing anything to mitigate the loss,
But what's his obligation, other than contract, what's his obligation to stop other people from gossiping about this?
Well, but the parent
Relationship.
said that he heard it from Inouye.
Okay,
He learned it from Inouye.
all right,
But
what's his obligation not to discuss it? It
but he
could be
wasn't
defamation.
discussing it he was discussing it in a manner that's not consistent with what happened. He's discussing it as if she's some loose woman who
But
goes around having.
That's a defamation claim, but you removed that claim.
Well, I did, but you're asking me what he did after he learned of the egregious conduct. So I removed the defamation claim, but that doesn't mean that his conduct doesn't arise to the level of negligence when he's continuing to pile on the harm.
Okay, all right, Mr. Friedman.
So Judge, I agree with Your Honor's question. To me, if you're alleging that post learning of the allegations, my client engaged in actions, intentional actions, those are intentional torts. So saying he harassed the child or was party to harassing this child, which we vehemently dispute, we believe the factual record be, but that's not before the court today. That would be an intentional act. That's not a negligent act, right? So that's not what's pled. And I keep coming back to Your Honor, what is the duty? I don't understand, I get the interplay between contract, but as this, the negligence claim itself, how have we articulated that he had a duty to act differently than he did? I understand morally or ethically, if you believe their facts, obviously my client disputes vehemently the way they characterized his actions and behaviors. But if you believe them, they may say, well, morally, we think he should have done something differently, or ethically, but that's not an articulable duty under the law, right? You'd have to articulate where he has this duty. And I don't see it. I don't see it pled, right? I don't believe that and it's a fundamental element. And I think the claim has to go. I mean, I give you 20 more minutes on it, Judge, but you went around and around on it. yes, there's some slight factual differences in what they've sort of tailored this complaint, but the fundamental elements and what's missing is still there. And that's what caused us to move to dismiss it in the first place. And that's why we're back here again today.
Look, my original inclination stand, I am denying the motion as to the breach of contract claim. I'm granting it as to the negligent infliction of emotional distress claim. My dismissal of the negligence claim is without prejudice. Ms. Rasmussen, if you want a third and final go at this, to try to articulate more more specifically what how the duty arose and what Mr. Inouye did that might rise to the level of the type of actions that's required for a negligent infliction of emotional distress claim, you're free to do so. Since it is a without prejudice dismissal, but as pled, I don't think it rises to a legally cognizable claim. All right, Mr. Friedman, will you please prepare the implementing order read by Ms. Rasmussen for comment? It's due in 2 weeks. We'll do an in-chamber status check on November 7th for submission of the order. Thank you.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Mr.